It's Conduit News Radio with Paul Harrell.
She's a former prosecutor. She was fired after teaching the Constitution to Tea Party groups, and she would not sacrifice liberty for a paycheck. She's a disabled veteran of the United States Army, a Russian linguist, a mother, a pastor's wife, and a patriot. Please welcome back to the program. We have KrisAnne Hall back with us. KrisAnne, thanks so much. Good morning to you.
Good morning to you. Thank you so much for having me back on the air. I'm excited.
Me too. I'm very excited as well. And, you know, the interview that we did, I think about a month ago, all of our audience just really loved it. A lot of them, KrisAnne, by the way, not only do they listen to this program, they also listen to your syndicated radio program as well, and they love how you stand for constitutional principles. And so they certainly wanted to get you back on the program, and so did I. So I'm glad that you're here. Well,
great. I'm excited. Lots of stuff going on, man.
Yeah, there is. There's a ton of stuff, and I want to get a couple of current event questions here in a minute. But one of the things on your website really stuck out to me as I was kind of doing a little research for this interview, where it talks about how you are able to teach the genealogy of the Constitution, and it says here a 700-year history and 5 foundational documents that are the very roots of American liberty. I mean, we may not have time to get into all of that, but 700 years. Can you tell us a little bit about that?
Yeah, there's a taught misconception in America that the Constitution is an invention of the men who wrote the document, as if they sat down in 1787 and said, hey, let's do this thing. It's really an evolution of British law, which sounds a little bit strange considering we don't teach accurate American history anymore. But we have to remember, you know, all those people that we think about as being the founders of America: George Washington, Benjamin Franklin, James Madison. None of them were Americans. As a matter of fact, there were no Americans until July 2nd, 1776. So what we have are people who were all British citizens. They were educated in the rights of Englishmen and the laws of Great Britain and the natural laws that is consistent with the security of life, liberty, and property of every individual. And so what happens then is you study that history and you learn why we are a constitutional republic and not the Kingdom of America. Because many people who are my age or a little bit older probably remember in school that there were people begging George Washington to be king. So we got to remember that we were very close to being the Kingdom of America, but there was a wisdom in history and experience that taught those who not only influenced but who created our constitutional republic, that said, hey, wait a minute, we have a single goal in mind. The single goal is the lead-off to the Declaration of Independence. It is established in the preamble to the Constitution. It's the whole purpose for the Bill of Rights. And that single goal was to preserve the blessings of liberty, not just to ourselves, but to our posterity. And they said, with that single goal in mind, we realize we cannot be a kingdom, we cannot be a democracy, we must be a constitutional republic. And so what we teach in that genealogy of the Constitution, the history of the Constitution, is that 700 years of life and government experience that is the history of our founders' heritage, that says, hey, we must be a constitutional republic to preserve liberty. And most people, it's kind of funny because not only are Americans taught that the Constitution erroneously is a living, breathing document, meaning, it doesn't mean what it says and it doesn't mean what it was intended to say. But the British people are also taught that their Constitution is living, breathing, only they tell them it's not in writing, which is pretty much the same thing. But the truth is the British history establishes their Constitution to be written in 5 documents. And if you like, I'll just name them real quick.
Yeah, that would be great. Please do.
Well, they start with the 1100 Charter of Liberties. The second document is the Magna Carta. The third is the Petition of Right of 1628. The fourth document is the Grand Remonstrance of 1641. And the fifth document is the English Bill of Rights of 1689. And this is the building of the rights of all Englishmen. And it's the same liberty and guaranteed liberty that our founders brought to America as English colonists.
So it's their rights as Englishmen, and they, I guess, what do they eventually say? Well, these rights don't go far enough because they're administered. They come from a king that can take those rights away when it's convenient. I mean, was that some of their thinking? And also, using like a 700-year reference point, I imagine they were also looking at some of the colossal failures of people and civilizations attempting to govern themselves.
Oh yeah, absolutely. They went to the wisdom of many governments in history, but the reason we teach this 700 years is because this is a direct written history. And these 5 documents actually create our Declaration of Independence, our Constitution, our Bill of Rights. So not only are the principles of our foundational documents pulled from these 5 documents, sometimes even the very language themselves are pulled from them. As a matter of fact, the Declaration of Independence is a legal requirement that comes from Clause 61 of the Magna Carta. It wasn't some kind of an invention of our founders. It was the requirement of all Englishmen, according to Clause 61 of the Magna Carta, to petition the government for a redress of grievances, to give them 40 days to comply and redress those grievances, and if the king and the crown refuses to redress the grievances within 40 days, the Magna Carta said that the people, with their local government, have the authority to assail the king and the court with all power necessary to make themselves whole. So the Declaration of Independence was a requirement and could not even existed without these documents. The 1100 Charter of Liberty actually establishes in writing that government can't do whatever it wants, and that there are limits to government, and that if government engages in certain activities, then government is evil and oppressive, and the people are righteously justified to resist those efforts of government. It's amazing because in the 1100 Charter of Liberties, which is written by a king, the king promises states will never have to pay the government before they receive their inheritance. Because if the heirs of an estate have to pay for their inheritance from the government before they receive it, he said, you have an evil and oppressive government. But yet here we have today, that should sound familiar, everybody, as inheritance tax or death tax. Mm-hmm. We have our government today charging inheritance tax or death tax, which in 1100 was earmarked as the efforts of an evil and oppressive government, but we allow our government to call it revenue. And I believe, and that's why we teach this history, that we have been failing. Through the failure of teaching this history, we've allowed government to engage in activity that would be classified throughout history as evil and oppressive because we've been taught the wrong things for a very long time.
Wow. Now that's just a ton of truth right there. You can feel it, ladies and gentlemen. That is incredible. And it really should make us all cherish what liberties we have left, because it seems to me like if we have forgotten so much of the truths that our ancestors knew, right, and yet, we are where we are today, it kind of should reinforce the severity of how serious this is. If we don't stand up for liberty now, the next generation, to reinvent the wheel, to rediscover these truths, it doesn't just happen automatically. It takes toil. It takes the diligence to secure these liberties. And so to me, it really just says, hey, we really have to well, we really have to get our stuff together, quite honestly, KrisAnne.
Yeah, well, it's really, really, it is the basic foundation for everything that I teach. We have LibertyFirstUniversity.com, which is our online training education, constitutional American history, civic government training. And it is the first course that everybody has to take at Liberty First University, because it is the foundation for everything. And frankly, it is a very, very stunning course because, well, you know, I've been teaching this for nearly a decade now, and people are shocked at how often history is repeated exactly. Mark Twain said history doesn't repeat, but it rhymes. He was wrong. He was simply wrong, because history does repeat, and it does repeat very, very precisely. The only thing that changes are the names and the dates. And this history class, the genealogy of the Constitution, I mean, I've had people throughout the years. I've had people with PhDs in American history, civics, PhDs in political science. I even had a Supreme Court justice in Texas tell me he learned more from me in 1 hour of that class than he learned in his entire education.
Wow. Yeah. Wow. What a rebuke of, you know, these institutions that we are, you know, you have to go here if you want to be somebody. You have to get a little certificate of paper from, you know, this law school or that law school, and yet we're not teaching the, you know, a lot of times, and, you know, you're an attorney, so you know, I mean, law schools are teaching court precedent and jurisprudence more than they're teaching about individual rights. Is that correct?
No, we don't teach the Constitution in law schools anymore. It hasn't been taught in law schools. You can ask any lawyer who has graduated in the last 20 years, maybe even more. We haven't taught the Constitution in law schools for a very long time. I graduated from the University of Florida, had 300 in my graduating class, and 90% of them will tell you they never even had to look at the Constitution during their education.
Wow.
We teach what you mentioned, precedent, which we teach constitutional law, not the Constitution, which some people like would be the same thing. Yeah, it should be the same thing, but it's not. What we teach are what we teach our law students, who will be future judges and lawyers, is that they know more about the Constitution than the history and the men who wrote it. And, you know, after all, they're a bunch of dead guys who didn't have cell phones, so what could they possibly know?
That's exactly right. I have a family member, my sister, who is an attorney, and she told me when she was in law school that one of the professors admitted to her that, look, technically all of these bureaucracies that the federal government has are completely unconstitutional. They violate the non-delegation clause, Article 1, Section 1, and yet they just say, but we just have to have these bureaucracies because we're just so big and we have to be able to manage our government. And so, you know, every now and then you just get those admissions, you know, like, look, yeah, this is illegal, but and if you are teaching law students from that position, then they're going to think that the document is malleable.
Right, exactly. And you know what? Part of what we teach, everything at Liberty First University is taught from original source documents. So I don't take somebody else's interpretation of history. I don't teach what the Supreme Courts or the law schools or even our colleges teach in error. What we do is a survey of the writings of the founders and their references to history to teach what the Constitution really is supposed to mean. The irony is we don't teach this, so this may sound a bit strange to some people who are listening, but the Constitution is a contract. It was written to be a contract with the intent of a contract, but a special kind of contract called a compact, which is an agreement between not people but sovereign governments, and in this case, our state. And our founders, knowing that it was a contract, fully expected the courts to enforce the Constitution like a contract. And the very first principle of contract law, every lawyer will have to admit, is a principle called the meeting of the minds, which means the meaning of the contract first comes from the drafters of the contract, and that contracts are not living, breathing documents, but documents written with the intent and the tenor of those who drafted them and those who signed them into law. And that's what we've lost. You know, this idea that the Constitution is a living, breathing document never survives in contract law. I mean, seriously, can you go ask your law professor, your dean of your law school, or your politician, if they would allow their employment contract to be a living, breathing document? They would think you're nuts, and yet they want the supreme contract of America to be living, breathing. And so we have to, that's why what we do at LibertyFirstUniversity.com is so important, because what we do is reestablish to the Americans what our document means. And by reestablishing what our document means, we put the power back in the people's hands to control the federal government the way it was supposed to be controlled, and not just simply through elections.
It's so well said. I have one question on current events, and then I know you have to run,
Okay.
and we're running short on time too. But I've so enjoyed this educational segment. I know our listeners have too. So Article 2, you know, the executive branch. We're hearing a lot about President Donald Trump potentially facing a subpoena to appear or be interviewed by Robert Mueller. But yet we have Donald Trump's lawyers, Jay Sekulow, Rudy Giuliani. They're saying, look, he's the president of the United States. We'll take this all the way to the Supreme Court. He doesn't have to comply with a subpoena. What are your thoughts on the powers of the president in this context, KrisAnne Hall?
Well, what we're talking about here again is the difference between what the Constitution says and what precedent says. Okay, so in studying Article 2 and the power of the president, we learn very clearly that the power of the president is very small on purpose. And the reason the power of the president is small, because they didn't want to establish a king. Many of those who were the founders and the creators of our Constitution were very concerned that by creating an executive branch who had a single person as the head of that executive branch, that over time that person would be able to collect power and become a king. So that's the first principle we need to understand when we're dealing with presidential power. What is the enumerated limited authority of the president, and what is the purpose of that power that is delegated? And so what the president's attorneys are talking about is precedent. There is no limitation in the Constitution for the President of the United States to not be subpoenaed. So will the Supreme Court uphold the precedent that the President can't be subpoenaed? Who knows? But the President is a civil officer, just like every other civil officer in the federal government. And to establish that the President cannot be subpoenaed would be to do exactly opposite of what our founders intended, that he and placed him in the realm of being above the law, or maybe even being very kingly. Now, the thing that we need to remember, that as an individual, as a president, even though he may be subpoenaed, he is not required to testify, because remember, the allegations are against him. And so he has the authority to say, you know what, I'm not going to testify because I'm not going to say anything that may or may not inadvertently indict myself. So I have the right to refuse to testify. And for me, if I was his attorney, I would give him that advice, because this subpoena is just ridiculous. Nobody is looking to get information from Donald Trump. They're looking to trap him into perjury because they have absolutely no credible charge against him at this time. So if you look at these hearings that have been happening, we realize that in these hearings, nobody's actually being charged with the purpose of the investigation. They're being charged with things that are simply not even related to the investigation, so that they can say that they have some kind of case and they have some kind of charges pending. So I firmly believe that if I were the president's counsel, I would say, look, you know, you can be subpoenaed. We can't shoot you from the subpoena, but you certainly should never testify, because all they're going to do is Donald Trump could go up there, be completely truthful and never lie, and all they would have to do is bring somebody and say, well, Donald Trump told me something else, and then the next thing you know, he's charged with perjury.
Yeah.
And the perjury charge would probably never go to court, right? But he would be tried in the court of public opinion, which is more powerful than true due process anyway.
Yeah, that's a really good point. I really appreciate that perspective all around. KrisAnne Hall, it's always great to have you on. You can find out more at KrisAnneHall.com or LibertyFirstUniversity.com. You heard her mention it several times. If you want to know more about the great information and substance she's presented here in this interview, LibertyFirstUniversity.com. KrisAnne, thank you so much for coming on the program.
Oh, it's always an honor, and I'll look forward to coming back.
Yes, absolutely. Thank you so much. KrisAnne Hall, everybody. Folks, this is Conduit News Radio. Look forward to the next interview with KrisAnne Hall, and we'll be back in just a moment.